number 1.
Lordship, in preferring the appeal, assigning the impugned judgment dated 2010-2023 and order of sentence dated 27-10-2000, there is a delay of 505 days, Lordship. And delay has been explained in the application in paragraph 4, 5,
when was the order
and
passed
6.
with a conviction order?
Conviction is 2010-2023.
5 days. Yes, Mr. Khan. We condone the delay, yes.
Lordship.
Your orders.
Daily list item number 1.
So the main appeal can be listed next week for admission?
Yes, they'll pass orders. I mean, we'll write orders.
May I please, Your Lordship? Lordship, in this case, Lordship, we have filed an IA bringing on record.
1 second.
As per the
Yes, Mr. Chetia.
Lordship, we are filing our affidavit today, my lord. We have served copy to the other side, my lord. So let it be on record, my lord. It may be taken up next week, lord.
Lordship, may kindly see the affidavit,
I've already
Lordship,
served you a copy of the affidavit.
Lordship, they have served me the copy of the
But it's
affidavit,
not before the court,
not
so
before
we
the
can't
court, Lordship. We have
consider it
confirmed
right
with the Lordship. Why
Can we pass on a copy to Lordship?
No.
Lordship, we have filed an IA bringing on record the subsequent action of the respondent authorities. We served the copy of the Lordship interim order to the respondent authorities. Lordship, may kindly see the miss case number 65 of 2025. 65 of 2025. And Lordship, at page 21.
1 second. This is not even before us. Yes.
Lordship, at page 21, Lordship, the interim order which was there, we served the copy of the interim order. Page 21.
Yes.
Lordship, may kindly see at page 22. In light of the above said order of the Honorable Court, the continued freezing of the above mentioned bank accounts of my clients amounts to a coercive action as in defiance of the directions of the Honorable Court. Therefore, I request your good office to issue
That we'll
necessary
have to
instructions.
consider. Let the affidavit come and record. We'll have it after 1 week.
Lordship,
exactly.
Lordship, I have no objection regarding that. Lordship, may kindly last Lordship at page 32, if your Lordship may kindly see. Page 32, Lordship, final. This is the order they give. Page 32.
After your representation.
Yes, your Lordship.
Yes.
Page 32, last two paragraph, Lordship. Therefore, in view of the discussion and to avoid leakage of revenue, this office shall not withdraw any bank attachment unless specifically directed by Honorable Court or any competent authority. So there has to be specific direction. This is what he said. They are ready to do it.
After 1 week, we will take it up. The miss case together with the affidavit.
Already no coercive action is done. If the defreezing of the accounts, if my lordship.
You file contempt? No.
Lordship, it should have been filed. We should have filed contempt. But Lordship, we don't want to take hitches with the department.
Yes.
My lord, in fact, my lord, they file appeal, my lord, and after filing appeal within 3 days, they file this petition, my lord. We are filing our stating that, my lord, this petition itself is not maintainable, my lord.
You brought it on record, that fact?
Yes.
According to file, yes, then file. Ms. S. Chetia, learned counsel for the income tax, has submitted that the affidavit on behalf of the respondent is being filed in the course of the day. Next by MSN Hawala, however, has made submissions with regard to the action of the income tax authorities and has also filed a miss case, which is also listed today. So as the affidavit, next paragraph, as the affidavit has since been filed, this is matter after 1 week.
Lordship, may kindly give a fixed date on 29th, Lordship.
29th.
Thursday, Lordship.
27th, Lordship. 29th, I have some.
Lordship,
You make up your mind. 28th, then yes.
Yes, your Lordship. 28th.
27th, Lord. 28th and 29th, my lord, I am given by lord.
29th is okay, Lordship.
Okay, 29th.
Yes, much obliged. 29th. Much obliged.
Item number 3. Item number 3.
Lordship, item number 3 is same.
Lord.
Yes, also.
Lordship, the interim may continue.
Interim order, yes. We'll continue.
Item number 4.
Lord, in item number 4, Lordship, I am appearing on behalf of the respondent number 2 and 3, my lord. We are praying for, my lord, 3 weeks time to file our affidavit.
Lordship, interim order may be extended, Lordship.
Yes, as prayed, further 3 weeks time allowed to the respondent number
2 and 3, Lordship.
20 to file affidavit, yes. Yes, after and so interim order to continue till next date, yes.
Highly obliged, Lordship.
Okay.
We have to take evidence. Yes.
Hearing.
Orders.
Item number 5.
Trustee. Number 5.
Wait, just a minute. May it please your lordship. Lordship, in this matter I am seeking for some accommodation, your lordship. By the last order I was directed to obtain some instruction, your lordship. Through oversight, your lordship, I could not.
It was a draft scheme.
Lordship, yes, there was a draft scheme, your lordship.
What happened to
As to whether that draft scheme will be applicable in the instant case or not, your lordship, I'm yet to seek the instruction, your lordship. Kindly allow me some more time, your
What's the
lordship.
other case pending for division bench?
Well, that is also concerning my lord, pension to the teachers.
No, is
Those
it
a college teacher, your lordship. Let me have the instruction, your lordship, whether that scheme will be applicable to this deficit school teacher or not.
I might have taken is similar teachers. Yes, Mr. Indy Shulai today, the AAG today has sought some accommodation and prays that without further.
Let it be 3 weeks, your lordship.
2 weeks time to obtain specific instructions.
Highly obliged.
Draft scheme, which is set to be introduced, which has been which has been formulated by the state of Meghalaya.
Lordship. Highly obliged, lordship.
Item number 6.
Sure.
My lord, this matter pertains to the equal pay for the equal work, my lord. Today, my lord, I am also seeking little accommodation. A few days I was having little problem, so I could not prepare properly, my lord. Only on the last date, my lord has put a question to me whether my clients are ad hoc or contractual. My lord, they are called casual workers, my lord. They are all casual workers. But over the period of time, they have obtained regular casual workers who are doing a regular job, my lord.
Under a scheme?
No, they were not under a scheme, my lord. They were not under a scheme. They were recruited on a need basis, continued, my lord, continued, and now there is an agreement also that.
But is there any kind of contractual agreement signed with them? With those
Contract.
people, you said they were taken. How they just appointed?
My lord, subsequently, my lord, what happened is that this regularization, but of course the issue before my lords are not regularization, pay parity, regularization, service benefits, these were the charter of demands of the union for many years, my lord. And consequently, my lord, it has come to an agreement, to one agreement, where it says that the members of the employees, the members of the union would be automatically renewed every year, my lord, every year.
Their employment?
Yes, their employment will be automatically renewed.
That's on record?
Yes, it is on record, my lord. But anyway, my lord, I'm just seeking for 1 week's accommodation. I had little eye infection, because of which...
Due to personal difficulty, so you will praise that matter be adjourned for 1 week.
My lord.
This is a matter, my lord, for equal pay for equal work. That is,
yes.
This is a case of equal pay for equal work. Your lordship would recall I concluded my argument showing that...
After 1 week, Mr. RP General,
Deeply obliged.
He's got some eye infection.
Yes.
Item number 7.
May it please your lordships. Lordship, I appear for the appellant. This is an appeal against the judgment of the learned single judge. I am praying for a short accommodation of 1 week, lordship.
You also?
File is not yet arrived because of the traffic, lordship. It's a personal difficulty. Kindly have it next week.
Where is Chamber and Polo?
Lordship. Oh. Kindly have it next week. We'll do the hearing, lordship.
Mr. SD counsel for the appellant. Please for accommodation. As the file
Lordship may record as personal difficulty.
Due to personal difficulty. Praise allowed just after 1 week.
Lordship, I am obliged.
Much blessed, Lordship.
That contempt pending before the single bench
yes,
also?
Yes, Lordship.
Over.
Much blessed, Lordship.
Press button. Continue the menu. Huh? You got the orders, yeah? You don't need to be there.
Any mention?
Please, Lordship. Lordship, beg to mention item number 22, Lordship. For respondent number 11, Lordship, kindly allow us 2 weeks' time.
Number?
22, Lordship.
Nelson Mukhtar.
Yes, Your Lordship.
For the statement.
What matter wrong?
Your
Service
Lordship,
matter.
service matter, Your Lordship.
11. Why?
22, Lordship. Item number 22.
Okay. After?
2 weeks, Lordship.
Your Lordship, I pray that the interim order may be extended.
Request of so yes, for respond number. Respond number?
11, Lordship.
11, that's matter of 2 weeks, yes. Interim order, when it shall continue the next date, yes.
Obliged, Your Lordship.
May I seek Your Lordship's permission to mention item 17, my Lord, this Anamika Dutta.
May I just...
Yes.
Some information today, my Lordship. I informed the learned counsel from the other side of the Lordship. Today I am slightly hit up. So I am waiting for...
So you take a date, yeah? You take a date. You have to accommodate.
My Lord, can it be in next week if it's not inconvenient for
me? We already here only. We are here to hear your cases.
Yes, only. If my learned...
mercy of lawyers, actually.
If my learned...
5th June.
No, but it will...
You take a date, please. You ask one of the juniors.
Okay, my Lord. I'll just take a date, my Lord. Anyway.
Yes.
Obliged, my Lord.
On the prayer of so-and-so, Mr. General, listen matter of so-and-so. Yes?
Please, my Lords. My Lords, item number 15 of the daily list, crave your Lordship's indulgence, my Lords. We filed a miscellaneous application. This is that golf matter, my Lords. Impleadment application has already been filed, but that's not on board. If my Lords also kindly take that up together.
But Mr. General, to answer first on his
foot, that's there. That's there, my Lords, but that miscellaneous application.
He has to overcome, he has to sustain this.
I think my learned
friend I am appearing for the respondent number 2 and 3.
The other board is sunk.
My Lord, my esteemed colleague is unable to appear, so we are appearing now. We have received the affidavit by my learned colleague yesterday evening. So in fact, I sought for...
call for the missed case?
My Lords.
Yes.
Call for the missed case.
Yes, please, Lordship. Lordship, I beg to mention item 25.
29?
25, Lordship. Cherry Tangme. Praying for 1 week's accommodation, Lordship.
This is Cherry Tangme Mara?
Lordship, please.
And for respondent number 7, 8, Lordship.
And for 6 and 9, Lordship.
25, okay, yes. 2 weeks.
I also have a similar prayer for item 28, Lordship. The 27, Lordship. Praying for 1 week's time, Lordship. Union is there, the other side.
2 weeks, yes.
Obliged.
Should beg to mention item number 26, Lordship. Should this matter can come up day after tomorrow, Lordship, as conducting counsel is unable to come today. If this matter can come up day after tomorrow, Lordship, we've spoken to them.
No objection,
Why day after
Lordship.
tomorrow?
Lordship, because today conducting counsel could not come, he was ready, Lordship.
He's not?
He was ready today but could not come to...
Who was the read not could not come?
Mr. Kira could not be able to come, Lordship.
After 1 week, we can't have orders to suit, so yes.
Obliged.
But I'd like to mention item number 23, madam. I need some instruction in this matter, madam. So I'm praying if this matter will be taken up next week, madam.
Time has been sought for filing rejoinder for quite some time, more than 3 times.
And the legal matter.
That is one aspect, Lordship. Another aspect is, Lordship, there are other teachers which are teaching in the school, Lordship. Now, because of the pendency of this school, of this matter, Lordship, the government...
No interim orders?
No interim orders.
Lordship, the government are not releasing the salary.
I'll take instructions.
Why not releasing salary?
I'll
No interim orders stopping the salary of the teachers.
There's no interim orders, Lordship.
No. That they should take a call on it. In other matters, even when they interim orders, so they do something, and when in matters no interim orders, nothing is done.
Because specifically instructions have come from the
After
government.
1 week.
After 1 week.
Yes.
Obliged.
Obliged, Lordship.
Yes, Your Lordship. Lordship, I'm praying for one withdrawal of the contempt matter, Lordship.
Where's that?
Lordship, I'm praying for listing it today, Lordship, for withdrawal.
Tomorrow.
Today, Lordship.
Why
For
today?
withdrawal. Because, Lordship, it has come just before, some time back, 2 days ago, Lordship. This is regarding the Nehu matter. Lordship is of the observation that I should file a fresh petition.
No advice coming from here. You
Lordship, I'm
come tomorrow.
for withdrawal.
Yes.
Supplementary list item number 1.
Yes, Mr. Sangma.
Mr. Lordship, Lordship, I'm filing this review petition here as per the order dated 16/4/2025 by the division bench. Now, what happened?
What the order division bench? What does it
Lordship,
say?
the division bench said that file a review before this honorable court. Now, the brief fact of the case is that
File review on what ground?
on the ground that only asking I have filed an appeal before the division bench only for allowing me to file a rejoinder affidavit before this honorable court.
The matter has been disposed of. What rejoinder do you want to file?
No, that was my prayer before that, because that was dismissed because I was not able to establish the original petitioner was not able to establish the locus, because court has categorically mentioned that who are you like this, whether you have the locus study to file a case. That was, and then another observation made by this honorable court is that no rejoinder was filed to establish the locus, to explain who.
So
is the
who appeal against the order? Take it up there.
Yes, Lordship. That's why I on the ground the case was dismissed. So I filed an appeal, Lordship. When I filed an appeal, after hearing my submission, court says that if you want to establish your locus, then you can go and file a review. That's why that's
What's wrong with the order?
The order says that in the original petition, Lordship, I will take.
Out single bench, what is wrong?
Order says that because it was dismissed on the ground that the original petitioner was not able to establish his locus. So, because another second aspect is because he was not able to explain, because
yes, then it was dismissed.
Yes, it was dismissed, and saying that then after that, then against that order, the review petitioner we went and filed an appeal.
Who's the
actually
petitioner?
Now I'll just explain this. Actually, the original petitioner, after the passing of the order by the learned single bench, he expired. After that, we filed the application for leave to file application in this case and continuation of delay.
Who filed for leave to
the legal heir of the original petitioner, who are claiming to be the lineage of the Nokma Akang. So we filed in our miscase application for leave for application and continuation of delay was allowed. And after hearing our submission in the original writ appeal 40, the division bench says that we want that you can file a review before the learned single bench. So we are only here that if the review petition is allowed, I can at least place my case, Your Lordship. I can at least place that. I can at least try to establish my locus, and also that who I am and how all the things. Because if this is not allowed, I cannot even place my case.
Then why did you place your case when the matter was taken up?
No, that Lordship, that at that time, some advocate was there actually. Maybe because there was some communication. I was not that. Advocate
and the matter was dismissed.
Yes, no, yes. Some advocate was taking up the case, Your Lordship. At least we just let issue notice go, and then the private respondent can.
Lordship, the review is not maintainable if Lordship will see the judgment of the division bench of 16th of April 25.
Where?
16th April.
This page 117, Lordship.
Let him say why it's not maintainable.
Lordship will see the 4th paragraph.
117. Yes.
We find from the impugned judgment and order dated 23rd April 2024 that the writ was dismissed inter alia on the ground that the original writ petitioner was not able to establish his locus to maintain the writ or even to specify the relief he wanted. He did not even file a rejoinder to the affidavits filed with the respondent in which the writ which resulted in admission of the averment and allegations made in the affidavits.
This is exactly what I am trying to submit.
Now, the learned advocate appearing for the appellant prays for an opportunity to file a rejoinder to establish the right of the original writ petitioner, so and so. Before the appellate court, such a prayer cannot be entertained. However, we dispose of this appeal by giving liberty to the appellant to take out a review or other appropriate application before the learned single judge for review of the impugned judgment and order, keeping all rights and contentions with regard to maintainability and merits of the application open. He has not filed a delay condonation application, Lordship. The judgment is of 23rd April 2024, for which he is seeking review.
That is, Lordship, only actually section 14 of the
Now,
limitation.
who are these review petitioners here? How are they related to the original petitioner?
Yes, it does not matter. This order in this case had already.
Who are they?
They are the legal head of the original petition. That issue has been dealt by the division bench. Your Lordship,
now you want to establish the locus of the person who's dead.
Locus
and then after that to decide your rights as being heirs of the person who's dead, establish his locus, get order recalled, the matter reheard, substituted by them. That's what you want.
Yes, Lordship. I will establish the locus of that order expired as well as.
What locus we have?
Now
what locus did that?
That one is actually, yes, mentioned. He is the Shra, means like he is the very important son of that lineage of that.
Anybody.
That's why, Lordship.
Then?
And he was appointed by the SCO Mahari. That is Sangma is a SCO. SCO means it's a clan. But all the Mahari members, the clan members, they have appointed him.
There was a miscase for condonation.
There is no miscase, Lordship.
The condonation delay actually as per the order from the division bench, there is no delay, of course. But from the
what do you mean there is no delay?
Yes, Lordship. Lordship,
when
that
file appeal.
Lordship, I filed an appeal that my appeal was actually there is a condonation was there. But in this, of course, that if that is the case, if it's required, then I will just file it. Actually,
that is the case.
But my condonation of delay on filing appeal, that has been condoned, Your Lordship. That is page 103.
Yes. You have to state the grounds of why you have come now. All those going to appeal, going here and there, that is all part of your excuses to make up sufficient causes. All. Dismiss this one now.
Lordship, I will just file a small application to mentioning the delay.
P.T. Samas submits that please be allowed to put an application for condonation.
Lordship.
As the application appears to be defective. At least up to 2 weeks, yes.
Lordship.
Obliged.
But it is allowed at least up to 2 weeks.
Obliged.
Much obliged, Lordship.
Item number 2.
May I please, Your Lordship? Your Lordship, this is a case where my bank account, Your Lordship, has been frozen, Your Lordship, in relation to a complaint, Your Lordship, pertaining to a UPI bank fraud, Your Lordship.
Okay.
So the complaint is an Annexure 1, Your Lordship, page 11.
Yes.
And my account has been listed at page number 24, serial number 84, Your Lordship.
Number 24.
Page number 24.
These are all the accounts?
Yes, Your Lordship. These are all the accounts.
Frozen?
Yes, Your Lordship. And my account has been listed at serial number 84.
24.
84.
84.
The page number of my petition is page number 24, Your Lordship.
Page?
Page 24. Serial number 84, Your Lordship. An amount of
the one which is flagged. I mean, it's not the photocopy that has not come out full.
An amount of 623 rupees, Your Lordship, has been credited into my account, Your Lordship.
Yes.
So thereafter, Your Lordship, I have received a letter from the bank, Your Lordship, at Annexure 3, Your Lordship, page number Annexure 3, page number 34, Your Lordship. Here, Your Lordship, I was informed by the bank that my bank account has been partially frozen, Your Lordship, based on the instructions received from the Director General of Police from Gujarat, Your Lordship.
Partial freezing means?
Meaning that only money can come inside, but I can't withdraw the money, Your Lordship. Only.
Yes.
Your Lordship, I am also a Class 1 contractor. I've been engaged in various government projects, Your Lordship. And there are certain funds which I have received in my bank account, Your Lordship, which I'm not able to withdraw because of this unlawful freezing of my bank account, Your Lordship.
Yes, but then we have to issue notice. Yes.
Your Lordship, first notice should go because Gujarat.
Where is this? Which state is this cybercrime investigation going on?
It's in Gujarat, Your Lordship.
So an amount of rupees 623 landed in your account.
Yes, Your Lordship. And based on that account, based on
that, to get the multitude of other accounts are here.
Actually, Your Lordship, Annexure 1 is the complaint. There are 94 fraud accounts. Complainant has filed and he is number 84. Petitioner is 84, serial number 84.
This amount came to your account?
Yes, Your Lordship.
You didn't, from where it came, you don't know?
No, Your Lordship. It was a small amount, 623.
You don't know who sent it to you? That's 623 rupees.
When I tried to withdraw money, that is when I couldn't withdraw money, so I went to the bank and inquired from the bank.
Last year it happened in 29/5/22.
Maybe it's a case of just wrong numbering. You know, this some scam going on in your account came there. 623 is a small amount. Share market scam. What is this? Yes, heard Mr. Pasmante, Council Petitioner. Issue notice MS advertising.
Respondent number 1, Your Lordship.
Correspondent number 1. Notice to go to the remaining respondents within 3 days. List up to 2 weeks. But there are too many cases like this now. This is the 4th or 5th case here in this court. There is freezing of UPI payment here.
Item number 3.
Another similar case, Mr. Interim.
Yes, Your Lordship. But in this case, the agreement has already been signed.
Will stay.
And as per,
he's collecting now also. What is
he's still in?
Your Lordship, actually, similar matter will be listed next week.
Your Lordship, as per the agreement, at Annexure 2, page 17, page 18, point number 10.
How long have you been running this revenue station?
Your Lordship?
How long have you been running it since?
Since January 20.
No, he's.
Since 27 of January.
Before that, also he's running, or just.
No. This is a new. This is a fresh case, Your Lordship. So we pray that the impugn order be stayed, Your Lordship, till that time. Because as per condition number 10, any dispute arising out of this agreement shall be referred to the executive committee for its final decision, and its award shall be final.
Where is that?
Page 18, Your Lordship, number 10. But the matter was not referred to the executive committee. The executive committee, the secretary has only issued this order with no reason.
Again, the one signed just before elections.
It was signed.
Your Lordship, 27 January is the same date where the model code of conduct commenced.
We'll do one thing. Heard Mr. R.K. Sindram, the Council Petitioner. Issue notice, Mr. Archival present, accept notice on behalf of the respondents number
126.
All the respondents.
All respondents. No further notice required. Stop. The case next part of the petitioner is that pursuant to an agreement dated 27 January 2025, he has been settled with the settled lessee for revenue collection on entry of vehicles carrying goods and livestock at Malangwir Makrowat, Southwest Casians. However, he submits by. Where's the impugn order?
Impugn order is Annexure 5, Lordship.
Impugn order dated 4th April 2025. The said permission for collection has been revoked by the respondents. He therefore prays that as he was not heard, and this action of the respondents being against the terms and conditions contained in the agreement dated 27 January. The impugn order be stayed. Stop. Next paragraph, Mr. Arkhas appeared the respondents submits that there are a batch of matters also pending consideration for this court, which are to come up shortly.
Yes.
Stop. Next paragraph. This court on hearing the parties. There are notice issue 1, the pray for interim stay, which will be taken up after 1 week. You come
matter is fixed on 29.
Interim orders next week.
29, my lord.
29.
Fixed on the 29. Hello, Blake.
Item number 4.
Lordship, in this matter, we are challenging the constitution of the.
There's a caveat, Mr.
There's a
Nongkar.
caveat, Lordship.
Who's appearing for the caveat? You received notice?
Yes, Lordship.
You've served them copy.
Yes, just caveat petition number 64/2025. There's a caveat filed by the. You've been arraigned as respondent also.
Lordship. Respondent 7.
Caveators who have been arraigned as respondents number
7
in the connected petition. Stop. The caveators represented by MS ML Cloud. Yes. Next paragraph. Only caveat stands discharged. Yes. What's the case?
Lordship, I'm aggrieved by an impugned order passed by the BDO, Lordship, whereby a Program Executive Implementation Committee (PEIC), Lordship, has been constituted.
What is
this
that?
pertains Program Executive Implementation Committee. Program Executive Implementation.
Part of the MNGRS scheme.
Lordship, it's part of it.
Yeah, then.
Lordship, basically they had constituted this PEIC, Lordship. So basically, we're challenging those two impugned orders, Lordship. Lordship, the
where's the when was it constituted?
Page 30, Lordship.
30.
30, Lordship. Lordship, this is an order dated 21st March 2025.
24th March.
21st March.
Where are you reading from?
Lordship, there are two orders, page 30 and page 31. The first order is page 30, Lordship.
You have to type copies.
Lordship, may be allowed to read, Lordship. In pursuance to the letter number dated 6 February 2025 and order dated 18 March 25, the office of the undersigned is pleased to temporarily constitute a Program Executive Implementation Committee (PIC) under the chairmanship of Sri Joybin Koch Gaubara, comprising of the following members. It is also unanimously decided that the Gram Sabha that Sri Shah Jahan Ali Ahmed shall be elected as a
secretary. So you're a secretary of the Program Implementation Committee now.
Lordship. Yes. Lordship, as per the scheme of 2006, Lordship, I'll just provide the scheme.
Why you aggrieved, Mr. Nongkar?
Lordship, I'll come to that.
Because program executive is just to make sure the programs are implemented, right?
Lordship, it works. So basically, the PIC works under the supervision of the VEC, Lordship.
Okay.
Scheme 7 of the scheme 2006 will say that, Lordship. Can you come to scheme number 7, Lordship? Page 3.
Internal page.
Internal page 3, Lordship.
Number 7.
7 local councils authorities. Then below a village employment council, Lordship.
Yeah.
1, 2. Can you come to 4, Lordship? 7.4. Each VC will have a Program Executive Implementation Committee which will implement the scheme in the village. The PIC will comprise of 5 persons who are conversant with MJNCA. Out of 5 members of the PIC, at least 2 members shall be female members. The chairman of the PIC shall be either traditional headman or a person elected by the VEC in consultation with the traditional village headman Darbar. So each PIC will have this PIC.
Each VEC has a PIC.
Lordship, in this village, there is no VEC at this present stage, Lordship, because the matter is pending before this court, Lordship, so far, and that election has been stayed, Lordship. So since there is no regular VEC,
there's no mechanism where the programs don't get stalled and they can.
Lordship,
put in a temporary PIC in place.
Lordship, so far as the election of the concerned village is concerned, Lordship, that has been stayed by your Lordship in some of the matters, Lordship.
Yeah, Mr. Singhan, is that correct?
Lordship, I'll provide the orders, Lordship.
In our matter, there is no stay.
Lordship, can you come to page?
1 second.
Can you come to page 28, Lordship? Lordship, the job card holders are suffering, Lordship. Page 28.
From last year, there have been no elections till now.
No elections, Lordship, because of this pendency of this writ petition, Lordship.
Now, what's happened to this petition?
Lordship, it's been adjourned time and time again. I'll just.
By whom?
Lordship, Lordship.
Well,
I'll just place. I'll just place the order sheets.
Not now.
I'll place the order sheets.
No, not now. We will.
Yes, my lord, if that matter
listen together, we'll dispose it off.
Lordship, it's.
You take notice. You want to file an affidavit.
Yes, Lordship, I'll file affidavit.
Within 1 week, you can file it.
Lordship.
Yes, Mr. Singhon?
I'll take instruction, my lord.
Yes, Rajasthan. The third, Mr. Evan Nongpur, issue notice. Mr. N. Singhon, it actually notice we have the respondents.
Yes, my lord, 1 to 6.
Yes, sir. Mr. N. Singhon is present except with 1 to 6, and Mr. Emil Talau, who Emil Talau is accept notice on behalf of as caveat appears for number 7. Stop. The grievance as set up by the petitioners are that despite of the absence of a VEC, a program implementation, what's it called?
Program executive.
Program executive implementation committee has been constituted. In which village is this?
Sobribari village. Sobribari
village. Stop. Next, Mr. Emil Nongpur has taken this court to has referred to the orders passed by this court, wherein the elections of the set of the set VEC for the village has been suspended by order dated 24/7.
16/7/24.
16/7/24. Stop. As the program, as the matter is linked to the set WPC number
248.
248. This case together with WPC number 248. Respondents may come with instructions or affidavits in the meanwhile. Yes.
Lordship, the impleadment order may be. Lordship, there's why I prefer an interim order. Lordship, kindly come to page.
We have it after 1 week.
Lordship, there are 503 job card holders in the VEC, Lordship. Now the sanction amount has been sanctioned only to 300 villages, 300 households, Lordship.
Item number 5.
We can't undo this.
Lordship.
.248 of 24.
This is a writ petition by which we are seeking declaration that the land acquisition process lapsed, my lord. This is with regard to Maxwellton.
Okay, I take it matter.
In my humble submission, there's nothing. My lord.
We have no objections. Lordships can take it up.
Well, here what happened, my lord, by invoking urgency clause, way back into 2001, my lord, the land acquisition proceedings was
No, but
initiated.
in the other matter, it said that the is before a special judicial officer.
But that has been disposed of, my lord. Against that, we had preferred an appeal. Lordships will recall. Against that final order, that appeal is still pending, my lord. The appeal was withdrawn with liberty, and we thereafter preferred an application under Article 227, challenging the awards and certain orders that were passed by the special court.
So they're not connected to this matter.
The property is the same, but here the subject matter is somewhat different. It relates to the same proceedings.
Then?
But here, my lord,
it will not complicate matters further.
My lord,
But if the payments have already been deposited in the other case, the amounts.
but the amount has been paid to one person, my lord, whereas there are as many as 87 residents, my lord, in the land.
Fine.
So we are those residents, my
So
lord.
if
We
they
have
are
not
part of the
received.
same process and one landowner has been paid, then
No, that payment was with regard to the award passed by the DC. Subsequently, the amount has been enhanced by an order passed by the special
these
court.
people are not party there in this
We are not
proceeding.
party anywhere, my lord.
Why?
Well, that's what collector will have to explain, my lord.
Notification has been issued, or the names were there.
Names are there,
Names
my
were
lord.
there, the names were there, Lord. The learned court proceeded without making them parties in
The
the
names
case.
were there.
The names
at
were
the
there.
time of when the matter was referred.
No, not during the reference. Not during the reference.
When the
but
collector passed
Or
the
when
award, my lord.
Okay, notifications issued by the collector.
They were tenants, my lord. They were not owners of the
Then
property.
what are they?
So the trial court proceeded to grant some sort of relief to them without hearing them, without
you pay
making them
them.
parties. But here, my lord, the challenge
My
is
lord,
very
we are not on
different.
payment, my lord. We don't want money, my lord. We are saying that land acquisition process, when it started by invoking urgency clause, my lord, and for 25 years the land acquisition proceedings are not complete till today, my lord. Neither the position has been taken. The land acquisition, my lord, the period is 2 years, my lord, for making the award. The state will
Send
file an
to
affidavit.
that court, which has other matter also. What to do?
Because I have no objection to Lordships taking it up.
You annex some orders of this court.
An order of this court whereby he sought a reference, my lord.
Where is that?
Page 110.
110.
110.
When was this? 21.
This was passed in 21. This related to the establishment of the special court in East Khasi Hills.
Under the new act, my lord.
This is an innocuous order.
Lordship.
My lord.
Lot of proceedings prior to this. Okay. What scheme is that? This Annexure 18 is the order of enhancement. Page 140.
My lord. My lord, what happened? There are 87 occupants of the land, my lord.
Only given here, see, in 160, the names are all there. Then?
The names are there, my lord.
But they did not participate, my lord. They were not even heard.
There? Then?
My lord, award has been issued to us.
160.
My lord, award is at page 115 itself, my lord.
Kindly see page 160.
My lord.
See, observe that made and so far no compensation has been paid to the persons who are found residing in said land.
My lord.
The OPS shall take possession of land according to provision of section 38 or so and so. The claimant is entitled to compensation as follows. But then your names are all here. Then
my lord, our case is, my lord.
How did you reconcile that?
My lord, our case is when this award was passed, my lord, the land acquisition is already lapsed by then, my lord.
That means it disables the entire award.
My lord.
That is the prayer.
Yes, then it disables the entire award, even pass in favor of the main landowner also.
Yes.
Then?
So the entire proceedings before the special court will be declared as void.
Then we can't have it in two courts the same matter.
Look, there what is under challenge is the final award.
We get it. That is
and
different.
an order passed in a review.
Now they have come up with another application that means that it's that window period is gone.
As far as we are concerned, my lord, the window period is gone. My lord.
So window period is gone, and so the entire proceedings are non-est in law.
My lord.
We'll file our affidavit in that case, in 2 weeks'
We'll
time.
file an affidavit, my lord.
But see, it should not complicate matters in the other case where enhancement has been done and so on and so forth. Then have you made that person a party here also?
We have not, but we are not seeking relief against him.
Why? They'll be affected.
If necessary, we will impede him.
It is necessary. Heard Dr. El Mozica also issue notice. Mr. S. N. Leonard come as present, accepts on behalf of all respondents for those called for. Stop this matter after 2 weeks for instructions or affidavit. Or we'll send it to let it be taken together with the other matter.
What's the file affidavit?
Item number 6.
I will complicate things.
Item number 6.
What is this?
But this is a land acquisition appeal, my lord. I am appealing for BSF in this matter. But here, my lord, about 2 acres of land was acquired for BSF outpost, my lord. in Beltoli's Indo-Bangla border, Khas Hills.
Where?
It's a Beltoli area, my lord. Beltoli.
Okay.
Now the original compensation was paid at the rate of 8 rupees per square feet, my lord. Now the Land Acquisition Court has enhanced it 20 times, my lord, to 160 rupees per square feet, plus imposed penal interest on us, my lord, at the rate of 15%. So against that we have come, my lord.
Yes, sir. Heard Dr. Muzika. We should notice to the respondents of
State is here, my lord, only one island.
Mr. SN issue notice for number 1 as the for number 2 referenced by Mr. SN. No further notice upon the said respondent. Steps to taken within 3 days now. The appeal shall be taken up for consideration. Let the records from the court of the special judge officer East Khas Shillong be called. Stop. Just after 2 weeks.
Well, we had an interim prayer. When an interim prayer was taken.
Where's the miss case?
Miss case number 8.
Number 8. Next, miss case number 8 is first appeal number 5/2025. This is an application for interim stay of operating judgment order dated 17/2/2025, passed by the court of the special justice officer, Land Acquisition Shillong, in Land Acquisition case number 5013. Stop. Appellant counsel for the appellant. Also, Mr. SN, respond number 2. On the pleadings made out in this case, the interim or the judgment order is 7/2/2025 shall remain state the next date.
Item number 7.
So notice in this case to the respond number 1 also.
My apologies, my lord. Yesterday the matter was called. I couldn't make it. My lord, here the issue is regarding pension, family pension, my lord. So, my lord, affidavit has also been filed here in this case by my colleague, my lord. My lord, I'm representing respondent number 1 and 2, the Treasury officer and the head of the office, my lord. So, my lord, in my humble submission, my lord.
1 and 3.
No, 3 is Senate board. We don't appear.
But the affidavit has filed on behalf of the 1, 2, 3.
What's that? No, but then it is filed by Treasury officer. So it could be a typography error. The affidavit hasn't filed Treasury officer, my lord, senior Treasury officer, my lord. So, my lord, in my humble submission.
Your affidavit covers Zilla Sainik Board also?
No, my lord, it should not cover because it should not cover. I believe there is some kind of an error here, my lord. Because the documents which have been enclosed in the affidavit and the averments are pertaining only to the Treasury, my lord.
But paragraph 1 says that 1, 2, 3.
Exactly.
This could be an error also, my lord, in my humble, because, my lord, if lordship will go through the affidavit, in the affidavit, the entire issue is pertaining, the informations that have been enclosed in the affidavits pertaining to the Treasury Department only, my lord. Senate board will have a different call in so
but
far as.
Will it have anything to say? No.
No, my lord.
It's not important. Only thing is that you have to provide, what is that?
Well, the letter.
Sometimes it has to, that Zilla Sainik, no, that pensionary, the pension process is to be initiated through the Zilla
Yes, my lord.
Sainik board.
That I am not.
That is the role, because there is some correspondence to the army through the Zilla Sainik board, lordship.
My lord, yes.
Here, lordship, if the treasury officer give the clarification to the.
My lord, clarification is in the PPO itself, in my humble submission, my lord. Lordship, the PPO has not been enclosed in the writ petition. So, first of all, my lord, as we have already stated in our affidavit, the entire document of the petitioner for, my lord, receiving the pensionary benefit through the bank, my lord, has already been given the month of July 2019. So, there is no record with us anymore, it's with the SBI. However, my lord, with my friend's help, my lord, I could have a copy of the PPO. If lordship will have the PPO, my lord, everything will be clear. The letter, it's, in my humble submission, my lord, the letter by the EMC is, my lord, they have not scrutinized the paper of the petitioner with sincerity, my lord. they should have gone through this letter, the PPO, my lord. If Lordship will have it, page number 3 of the PPO, my lord. My lord, in page number 3, Lordship will see, my lord, in the horizontal, my lord, Indian military pensioner, my lord. So they are from the military pension of 1978.
Where are you reading from?
My lord, on the left-hand side, my lord, page 3, left-hand side, Indian military pensioner, my lord. And he retired from 1978, my lord. So, my lord, basically, he is a central government pensioner, my lord, in my humble submission. And, my lord, the another issue of the LTA, which they are saying, my lord. Lordship may kindly come to page 8. Lordship, have it page 8, my lord.
Yes.
My lord, at point number 3, my lord, 1, 2, and 3. Lordship, it's not very clear, but LTA, my lifetime area, my lord. This was till the year 2008, my lord. He passed away in 2008. Then thereafter, my lord, the fourth column will show that it's a family pension. So the question of this portion, they should have looked into this.
Why? One thing is that it is not your possession, Mr. Sheikh.
My lord, that PPO is with me, Lordship.
We
have given all the document that there is no, my lord.
Why did you close the petition?
My lord, in fact, with the PPO, there is no dispute with the PPO. PPO has.
So, if what is MS Kolni has said, whatever details that you're seeking,
my lord will kindly appreciate. The joint notification has already been done. Now only they are asking the clarification if the pensioner died in 2008 and why you have released the pension till 2019. That is the clarification they need to give.
PPO is my explanation. My family pension, it was converted.
Joint notification also done. My lord will kindly.
And my lord, the second page of the PPO also will show that the family, this petitioner before Lordship is the wife. So PPO itself should have been, my lord, properly looked into by the concerned officer. I do not understand, my lord.
Waiting for the Army Medical Corps.
My lord, they have not been make a party also.
Why?
So my lord, Treasury has already forwarded.
My lord, that army, because I have to go Armed Forces Tribunal, Lordship. So far as my lord will kindly see.
Why?
My lord will kindly see, I do not have any grievances against the army, Lordship. They are in fact saying that please provide the details because that pensioner.
If the courts will issue directions that the PPO contains all the details, will suffice to meet the requirements, there doesn't have to be a party.
Yes,
so avoiding Armed Forces Tribunal coming here.
My lord will kindly. My lord, whether that PPO is
making your job harder for yourself.
My lord will kindly see, Lordship. Lordship will kindly
see the election 9.
Yes, Lordship.
But all the correspondence are done by the army, my lord. And the letters are sometimes addressed to the Treasury, sometimes the State Bank. When we have already sent all, if PPO was produced, my lord, I don't think
that
so.
That PPO is already there. They have gone through the PPO, Lordship. There is no question with regard to the PPO, Lordship.
They have not gone thoroughly, my lord.
Mr. Sheikh,
my lord,
if we don't make them party, then no relief can be forthcoming.
My lord, they
are asking for a fresh lifetime arrears certificate. Like it is contained there. The directions are issued to them.
No, who will issue the lifetime arrears certificate, Lordship?
It's already there in the PPO. They've already issued it. It's already recorded there. It's recorded here.
My lord will kindly appreciate one thing.
Take instructions. Otherwise, we'll dismiss it for go to alternate. Because it's not maintainable jurisdiction. We don't have jurisdiction to take this matter here.
Yes. I'll take it.
Item number 8.
They are necessary party.
They are.
You're drawing pension from them.
Because they could have sort of the entire.
The process. You're not made them party.
The petitioner would not have suffered this long.
My lord,
making the petitioner suffer for nothing. Yes. Just after 1 week, enable after hearing at some length, just after 1 week, enable Mr. S.A. Sheikh to obtain specific instructions. Yes. You keep in mind what the court has said. Yes. Yes.
My lord, I seek my lord's permission to withdraw this petition, my lord.
What's it about?
My lord, this is that petition where my lord.
But the issue of territorial jurisdiction, my lord.
On the prayer of Mr. P.O. Bin, who submits instructions, may be allowed to withdraw the petition. Prayer is allowed.
My lord, with liberty, my lord, to have.
Yes, so you've been far away. Submits instructions, he may be allowed to withdraw the instrument petition. I would liberty to file a fresh so advised.
My lord.
Next paragraph, Mr. Dr. Mbosi has no objection. Last paragraph, upon the matter stands withdrawn and disposed of Our liberty as spread.
My lord. Obliged.
Daily list, item number 1.
My lord, here that KP is out of station, lordship.
Who is there out of station?
That KP Bhattacharya, lordship. Because
Mr. Pig, you were on sanction leave just after 2 weeks. Yes. Not sanction leave.
Item number 2.
May it please your lordship.
Yes.
Well, the pleading has been exchanged, my lord. There is some urgency on the part of FCI, that's why it's for final disposal.
Today?
Well, that is the urgency, my lord.
Because, my lord, this tender is going to expire on 22, my lord. Everything will go, my lord.
Yes.
Very small issue, my lord.
My lord,
You condense your submissions.
my lord, yeah. My lord, what happened, my lord? I am given a contract for transportation which is valid till February 2026. So they floated a tender for the same destination earlier, my lord. We came to this High Honorable Court, filed a petition, my lord. After that, they have withdrawn it. They have again issued this NIT, which is at page 83, my lord. This is another challenge, my lord.
83. Section 9.
Section 9, my lord.
Yeah.
Handling and transport contract on regular basis for transportation of food grain, allied materials from RH Girinia to FSD Arundhati Nagar via so and via so, including loading, unloading, so and so. So, my lord, this tender is a composite tender. Earlier, my lord, the transportation contract was different and the handling contract was different. Both I am doing. Now, handling contract is expiring this month, 31st of this, but the transportation contract subsists till February 2026, my lord. So, we came and challenged it. There's an interim order, my lord. Now, in the meantime, there has been some development, my lord. In the reply, they have said that they have the difficulty because the handling contract is expiring this month, and the transportation contract is February 2026. They want to issue a composite tender. Since the handling
transportation done by same person.
Same person.
Yeah.
So that they have given some reason. So since handling is expiring in May 2025, my lord, so they issued this tender. This is the reason, my lord. Now, while this case is pending, my lord, there has been some development. My lord, they have already issued an ad hoc tender for the handling contract. Now,
to you?
No, that process has been issued, my lord.
To the.
So this solves their problem, my lord. This handling ad hoc will continue till we continue February, and they can issue composite tender, my lord.
After February.
After February, my lord. That they have given now.
That means you don't have any grievance anymore.
If they stick to this, my lord, if they say this, my lord.
Mr. Singh.
I will satisfy your lordship, my lord.
Yes, so you say that if they go ahead with this bid document dated 6/5/25, you have no objection.
I have no objection because then that objection they raised in their affidavit also. The reason for which they have issued this impugned tender.
So they issue a composite tender, so you can bid for that again.
After February. So my term is completed. My term is till February 2006, and this one also continues that time, my lord.
Where's the time given here?
My lord, this is for
16. This is wait 1 second.
6 months.
Where's the
Contract period was 6 months, first page, my lord.
Yes. So where's the time given?
6 months. 6 months will cover that period, my lord. 6 months, and then another 3 months they can always extend, my lord. Ad hoc case, my lord. So 9 months period. So that will cover my February 2026. What I'm submitting, my lord, going by their own objection. I have not gone to the merit of the case, my lord.
What you want is that if they settle ad hoc with you, now when your handling transportation contract handling gets over in May, you want to settle composite with you till 26. Then you have no grievance after that.
Then I have no my only contention is that I am having a valid contract till 2000. The arbitrariness is that you cannot float another tender for the same route, giving me a contract. I'll be relying on a Supreme Court decision, my lord, categorically deal this position, this 2024 decision. Deal this, you cannot do this in this light manner. You cannot, because when a party comes to a contract, he invests the money and he has a trust in the system. So at any moment you cannot cancel like that. I'll come to that, my lord. Now, if my lord, now Lordship may kindly see the factual part I have submitted before Lordship. Now coming to the merit, because he is not agreeing to this possibly. So Lordship may kindly see what is their contention in the affidavit in reply, my lord. My lord, page 4 of their reply, my lord. Firstly, they have said, page 4, my lord.
Yes.
They have said that they have invoked this power to cancel indirectly cancel my tender, invoking clause 8.2 of the tender document. The general manager reserves the right to terminate the contract at any time during its cancellation without assigning any reason, whereof by giving 30 days notice and so and so, so and so. So this power they have invoked, my lord. Now, my lord, my submission would be, my lord, there is no complaint on their part that I have violated any terms of the contract. Now, Supreme Court has categorically said in that judgment that when the terms of the contract has not been violated, this term of the this clause cannot be taken resort to, my lord.
Where's the judgment?
I'll place that, my lord, at the end of it. Now, why they have done that, they have clarified in paragraph 12. The invoking power they have given, and then paragraph 12, why they have done, my lord, the reason. This is very important, my lord. The statements made in paragraph 13 of the writ petition are not wholly correct, and as I deny the statement which are not so and so. In this regard, I say that as per the standing instruction of the corporation, invitation of tender is to be carried out 6 months prior to the expiry of the regular contract. Well, this is in my favor. As the finalization of the tender may take several attempts to obtain competitive rates, the NIT dated 16/1/2025 was invited as the existing handling contract of the petitioner at FSD Arundhati Nagar is expiring on 31st May 2025. So this is the reason they floated the tender. Moreover, the positioning of the contract depends on the tender outcome of the economic feasibility. FCI is exploring the possibility of positioning a composite contract involving both handling and transport operation in Arundhati Nagar for operational feasibility, having a single conductor, meaning so and so, so and so, route optimization and cost effectiveness.
Yes.
So the composite contract they have floated, given 3 reasons, my lord. Operation feasibility, reason is route optimization and cost effectiveness. Now this is the reason, my lord, I straightway come to this Supreme Court judgment, my lord. I have a copy, my lord. Can you see? 2024 SCC online,
yes.
SC 1682. Now, Lordship may kindly see first paragraph 60. 60. That will be page 27. I have marked it, my lord, by hand, my lord. It says that this clause cannot be invoked. As your lordship got in.
Yes.
Now, coming to the facts of the case in hand, the appellant has challenged the cancellation of the tender at the instance of the respondents on the ground of being manifestly arbitrary and influenced by extraneous consideration. It is evidence from the notice of cancellation dated so and so that the tender was not terminated pursuant to any terms of the contract subsisting between the parties. Rather, the respondent cancelled the tender, saying that there was technical fault in the tender that was floated. Thus, the respondent could be said to have exercised powers in his executive capacity as the action to cancel falls outside the purview of the terms of the contract. This is my contention, my lord. Hence, it cannot be said that the present matter is purely contractual dispute. It is not a breach of contract, as no such breach has been imputed to the appellant in terms of the contract, but rather a plain and simple exercise of the executive power. So, my lord, the clause they have resorted to, my lord, that 8.2, clause 8, that is not applicable because I have not violated in terms of the contract. This is an executive contract which says that for certain reasons they want to do it. Thus, at the present dispute, even if related to a tender, cannot be termed as a pure contractual dispute, as the dispute involves a public law element. Although there is no discharge of a public function by the respondent towards the appellant, yet there is a right to public law action vested so and so. So, my lord, this says that breach is maintainable, my lord.
No,
Now,
you read middle because arbitrariness on the part of the
my lord.
authority.
No, why I'm saying, my lord, only for the proposition that the clause they are resorting to cancel me, my lord, that clause is not available to me because I have not violated in terms of the contract. This is an administrative decision. Now, Lordship may kindly see.
Yes.
My lord, paragraph 72 and 73.
Yes.
That will be page, my lord. Page 30, my lord.
Yes.
But they have shown a financial the savings sum and the cost part, my lord. Whether the action of cancel, has your lordship got it, my lord?
Yes.
Whether the action of cancelling the tender is arbitrary, unfair, in consequence of violation of Article 14. The principal contention of the appellant is that the notice of cancellation dated so and so was that was issued by the respondent is manifestly arbitrary so and so. Before we proceed to determine whether the cancellation tender could be terminated as arbitrary, it is necessary to understand the stance of the respondents in the present litigation as discernible from their pleading. First, that the tender had to be cancelled as there was a technical fault. The tender was found to be non-specific and not well defined. As a result, it created ambiguity resulting financial losses to the respondent. Secondly, the cancellation was also on account of a change in the policy. So both the conditions are present. They are saying the change of policy, that composite tender, and then they are also saying that cost effectiveness, they have taken this decision, my lord. Now, Lordship may kindly see.
That's the only reason they've taken is to make it cost effective that the same person handles both handling and transportation.
My lord.
Yes.
My lord, paragraph 112 and 113 has answered this question, my lord. That page 39.
112.
Page 39, running page, my lord.
Yes.
Has the lordship got it, my lord?
Yes.
Even assuming for a moment that there was a technical fault in the matter, which if rectified, has the possibility of generating more revenue. Here, cost cutting, my lord, the same thing, my lord, cost part. The same by no stretch could be said to be a cause and reason of cancelling an already existing tender. In this regard, reference may be made to the decision of the court in so and so case, wherein it has been held that mere possibility of more money in public coffers does not itself serve public interest. A blanket claim of the state claiming loss of public money cannot be used to forego contractual obligation, especially when it is not based on any evidence or examination, as the larger interest of upholding contract is also in the play. The relevant observation is same thing has been recited. I'm not reading, my lord. 113. In so and so case, this court held that wherever a public authority seeks to resile or relieve itself from the enforcement of a promise made or obligation undertaken in the name of public interest, it is legally bound to first show the material or circumstances by which public interest would be jeopardized if the enforcement is insisted. 14, my lord, we may again refer to the decision of the court on so and so again, wherein the court has observed that merely because the rates embodied in the contracts with the passage of time have become less appealing, the same cannot become a determinative criterion for either terminating the contract or for the courts to decline the interference so and so. So only showing the cost reason, my lord, you cannot terminate a contract. Now I am coming to the final part, my lord, page 126. Here it says, my lord, what are the principles to be followed in case of termination of a contract, my lord?
1 second. Para 126.
126, page 42, my lord. My lord, court has from 123 onward, court has cited all Supreme Court decision. I am coming to the finding, my lord, for 126. The sanctity of public tenders lie in the role of upholding the principle of equal opportunity and fairness. Once a contract has come into existence through a valid tendering process, its termination must adhere strictly to the terms of the contract, with the executive powers to be exercised only in exceptional cases by the public authorities, and not that too in Lothe. The courts are duty bound to jealously protect the sanctity of any tender that has been duly conducted and concluded, by ensuring that the larger public interest is upholding. Bindingness of contracts are not sidelined by the capricious and arbitrary exercise of power by the state. It is the duty of the court to interfere in contractual matters that have fallen prey to an arbitrary action of the authorities in the guise of technical fault, policy change, or public interest. The sanctity of contract is a fundamental principle that underpins the stability and predictability of legal and commercial relationship. When the public authorities enter into contracts, they create legitimate expectation that the state will honor its obligation. Arbitrary or unreasonable termination undermine these expectations and erode the trust of private players from the public procurement process and tenders. Once a contract is entered, there is a legitimate expectation that the obligations arising from the contract will be honored. 128, my lord. Cancellation of a contract deprives a person from his very valuable right and is a very drastic steps, often due to significant investment having already been made by the parties involved during the substance of contract. Failure on the part of the court to jealously protect the binding nature of a lawful and valid tender would erode public faith in contracts.
Yes, Mr. Singh.
May it please your lordship. At the outset, the petitioner, this writ petition is not maintainable on the count that the petitioner cannot approbate and reprobate at the same time. Petitioner having participated, my lord, petitioner has participated in the tender.
New tender also?
Yes, my lord. Without protest, my lord.
In the new, that is 16
in this 16/1/2025, that is annexed and pointed out by my lord friend.
Is that correct?
It is correct, my lord.
Then
there are decisions, my lord.
No, you have not said that. Why? But why did you take part? If you feel that your rights are being eroded.
Their contention, my lord. Why? I am, my lord. Why I am Lordship kindly see. First thing, Lordship kindly see. I have challenged the tender on the count of arbitrariness on the face of the
Fine, that's
yes.
all right. That's very
now
good.
I have participated.
But even then, yes,
my lordship
you already made a case that it's not a case of a pure contractual dispute, and so you can exercise powers. You can invoke 226. Correct. Right. That's one part. Other part is that if you have already submitted yourself, if the fresh tender, then what remains? Suppose you settle with a new tender, you'll take that, and what happens with this proceeding?
No. That has been I was responsive in the process, but I am not the L1. Now, Lordship kindly see.
You're not L1, that's why you've come by this petition.
No. That's why I'm clarifying that point, my lord. When the tender was participated, I have participated. I was responsive to the. It's not that I did not satisfy the tender conditions, my lord. I have come before this court before the tenders were opened. Your lordship passed a stay order in spite thereof, my lord.
By that time, tender technical bid was opened, my lord. And we have not finalized.
No, I qualified that, my lord. The price bid was not. But in spite of your lordship passed the order, my lord, they have carried forward with
the. We have not finalized it.
No. The order is that not to go ahead with the tender. They have opened the price bid, my lord. Now, there I have not qualified. Lordship, kindly see, I was responsive to the bid.
See,
it's not that
one thing, you file for damages then. Since you have already taken part in the tender, you won't interfere.
I am relying on certain judgments, my lord.
Let them file for damages. If you feel you are entitled to any civil reliefs, you vested with some right, you vested to some civil consequences then.
I am placing this Jagdish Mandal also, my lord.
Lordship,
where we can claim damages, my lord.
Where in the affidavit you said that have taken part? In the affidavit, where is it?
My lord, at page 3 of my affidavit in opposition, paragraph 4, my lord.
Mr. Chakravarti, you should have said that at the outset. That you've taken part.
Paragraph 4, may I read it, my lord? That at the outset, the instant writ petition is not maintainable in as much as the petitioner having participated in the NIT dated 16/1/2025 also prayed for quashing and setting aside the impugn NIT dated 16/1/2025. Therefore, having participated in the NIT dated 16/1/2025, the petitioner cannot challenge the NIT NIT impugn in the instant writ petition, my lord. Further, I have taken also ground in my Sir rejoinder at para 6, my lord, at page 5.
Para 6.
At page 5 of my Sir rejoinder, my lord. Para 6, my lord. In mid part, in this regard, I say that the petitioner having participated as one of the bidder in the NIT dated 16/1/2025 with the expectation of being successful in the said NIT, having accepted its terms and conditions, and is now precluded from challenging the said NIT, my lord. My lord, further, I would rely on my paragraph 12, my lord, why we have going for the composite appointment, my lord, composite tender, my lord.
Yes, sir, rejoinder.
In my affidavit in opposition, my lord, paragraph 7, paragraph 12 at page 7. I'm sorry, paragraph 15, page 9, my lord.
Yes.
I say that the corporation runs on government subsidy. As such, it strives to bring in the operational feasibility, cost effectiveness, and competitive rates for execution of day-to-day work. Several composite tenders have been placed by the FCI NEF region at various centers in Tripura like Kumarghat, Dharmanagar, Udaipur, Chandrapur, Sabrum, Jirinia, Madhabari. All the centers in the Tripura have composite contract except the Arundhati Nagar, that is present NIT, my lord. Considering nearing the expiry of the handling contract at Arundhati Nagar as an opportunity, the NIT for the composite tender was invited in the best interest of the corporation. Therefore, the invitation positioning of the composite tender 6 months well in advance is no way arbitrary as alleged, but is merely a regular practice of the corporation for bringing in operational feasibility and cost effectiveness. My lord, Annexure E, we have annexed the various composite contracts, my lord, 1, 2, 3, 4, 5, 6 composite NIT, my lord, which have been settled, my lord, appointment letter we have annexed as Annexure E, my lord. Now, my lord, the committee report at page 16 of my Sir rejoinder.
Page
16, my lord.
Para 16 or page 16?
Page 16, my lord. It is annexed with the Sir rejoinder as Annexure E, my lord.
Committee report.
Committee report on the identification of clusters to be considered for possible contract arrangements. The number 1 is DO Aizel Mizoram, that is not relevant. Next page at page 17, DO Agartala Tripura, my lord. A Gerenia cluster. Presently, there are 6 contracts in the proposed cluster which are given below. So and so, so and so. It is pertinent to note that all the 3 godowns, that is FSD Madhavbari, FSD Arundhati Nagar, and FSD Nandanagar, lie under the West Tripura Revenue District and are fed from Gerenia railhead. All the 3 godowns also fall within the limit of 30 km approx. So the cluster formation may provide better economies of scale along with the efficient labor management and improved transportation works. In view of above, Gerenia cluster seems feasible, and therefore the aforesaid 6 contracts may be merged into a single composite contract. Now, this committee report is of 11/7/2024. So this we have taken decision in the year 2024 only to call for all the composite contract, my lord. So only this Arundhati Nagar was left out. So this 16/1/2025, my lord. Now the petitioner has also participated, my lord. So
yes, what judgment do you have?
And we have not invoked the clause, specifically clause 8, as pointed out by my learned friend. That's clause 8 says that we, number 1, my lord, one who approbate cannot reprobate, my lord, 1981 SSC 537 para 50. My lord, para 50 at page, I think it is at 12, my lord. Down below the page number is given.
Where from the compilation?
Yes, my lord, compilation. That number 1, my lord, citations which I have flag marked it. In that citations, para 50, my lord.
D1 SSC.
My lord, my lord.
Para?
Para 50. Above is the page marking 13 of 15, my lord. Page 13.
Yes, fundamental principle.
It is a fundamental principle of general application that if a person of his own accord accepts a contract on certain terms and works out the contract, he cannot be allowed to adhere to and abide by some of the terms of the contract which proved advantageous to him and repudiate the other terms of the same contract which might be disadvantageous to him. The maxim is quo approbate, non reprobate. One who approbates cannot reprobate. The principle, though is originally borrowed from Scots law, is now firmly embodied in English common law. According to it, a party to an instrument or transactions cannot take advantage of one part of the document or transactions and reject the rest. That is to say, no party can accept and reject the same instrument or transactions. Now, my lord, second, number 2, my lord. The legal principle establishes that a party who participates in a tender process cannot subsequently challenge the terms and the conditions of the tender. If a party participates without protest, then they are stopped from raising the objections later on. My lord, this is from the Jammu and Kashmir High Court, my lord. Para 56.
Yes.
Lordship will get page 9 down below. In the present case, the petitioner have challenged the terms and conditions of the tender after having participated in the same. In context of a tender participation, the legal principle established is that a party who participates in a tender process cannot subsequently challenge the terms and conditions of that tender. The principle is rooted in the idea that the participation implies acceptance of the terms and conditions laid out in the tender documents. If a party has participated without protest, then they are generally stopped from raising the objections later on, my lord. So, my lord, he has participated without any protest, my lord. Then number 3, my lord, it is a settled.
Yes.
It is a settled law that a person who consciously takes part in the process of selection cannot thereafter turn around the question the method of selection. My lord, this is regarding the written examination. Now, my lord, number 4, my lord, the court, that Michigan rubber, the court who would normally not interfere with the policy decision in the matter challenging the award of the state or the public authorities. Para 35, my lord.
Yes, we've seen that, yes.
And number 5, my lord, Jagdish Mandal, my lord.
Yes.
So, my lord, the ad hoc appointment we have floated, my lord, for handling. That is for, my lord, whenever this regular contract is finalized, my lord.
Anything else to say, Mr. Gurti? Yes.
My lord, Worship, kindly see in view of in view of the fact situation, my lord, since they have already floated the ad hoc tender of handling, it means that it will continue for 6-7 months. And what again, their main point is that they have nothing to do with that I have done anything wrong with while executing. They are saying that composite.
For your case, totally different. You maybe had a case with regard to arbitrariness on the part of the respondents in truncating your contract to May only, when the new tender has floated and would take effect from. Okay, for the remaining 6 months. It's just for that gap period. Now you had a case maybe on arbitrariness because you have not violated any terms and conditions, and it's outside the terms and conditions, so it's not a contractual dispute also. It's a executive decision has been taken and has gone against you. But by the fact that you've taken part, because once you participate, it implies acceptance.
That's why, my lord.
So that is why. So that you can't get over. You can't say that that I'm not agree with the terms and conditions. I challenged it. I'm agree with the floating of the contract. That's why you try to put this one part that you're challenging the arbitrariness, another part is that you're participating because you don't agree with the terms and conditions. You can't have that both. You can't have your cake and eat it too.
My lord, this regarding participation and challenging, it started from Motherland versus Jammu and Kashmir. It started from that, my lord. But thereafter, Lordship will find in judgments, my lord. He said that it goes against me, but this is not an absolute. If the second process is absolutely arbitrary.
It's public interest. You understand? It involves food grains.
Public, yes,
and we cannot have any dislocation.
My lord.
That's the only thing.
But the public interest, your Lordship will consider.
Orders, yes. Only open court, but we'll be pressed for time.
Only one thing, Lordship, kindly see regarding this participation, my lord. Lordship, kindly see my conduct. It is not that after I was rejected, I have come, my lord. I have taken a stay order from this court. That tender should not be open, my lord.
They are not
No,
open
that
yet.
it is not there, my lord. We have not finalized it, my lord.
So, my lord, there was no malice on this part, my lord. When I participated, my lord, here,
Obliged,
my lord, I had come before that, my lord. Not that afterwards.
Suppose, Mr. Rawati, your client has succeeded.
Then
where would you be? Would you still
they
continue
have
the
withdrawn
proceedings
this
to
writ
sit after
petition.
this with regard to can you seal on two boards? Can you say suppose you have put in your bid, you are successful, you have given the handling contract also.
Well,
for then what would your position be?
Had I succeeded in the composite tender, my lord, I would have got it, my lord. Then to say
then you just abandon this case.
That's
Right?
yes.
Then
Item number 4.
yes.
Item
Obliged, my
number 4.
lord.
Yes. Yes.
May it please, Your
What
Lordship.
is this?
Your Lordship, the petitioner wants to withdraw this instant case.
You want to withdraw?
Yes, my lord. As the instruction from the petitioner, my lord.
Yes, MSS number 6 submits instructions that he be allowed to praise that he will be allowed to submit instructions and praise that he will be allowed to withdraw the petition stuff. See not objected to by counsels for the respondents. Accordingly, understands close on withdrawal.
Highly obliged, my lord.
Item number 5.
What's happened in investigation? Did this report with missing con?
My lord, investigation, my lord, still going on. My lord, I have a small suggestion, my lord. Here, my lord, we are not getting that much of cooperation even from the bank also. Because
the bank. Why not cooperating?
We are cooperating. This, ultimately,
direct to reimburse the amount and you find your own way to recover it from the.
Ultimately, my lord, transaction was done through the bank. Now, bank is not able to give us the detail in whose account the money has been transferred. And my lord, we have also written to the National Payment Corporation of India, my lord. We are not getting any response from them. So only one suggestion, my lord, if petitioner can make National Payment Corporation of India as a party. So it will
What
be,
is that?
my lord,
Well, that's the portal through which all these payments are transacted.
this NPCI, my lord.
Portal, maybe the different portal you have to go.
NPCI is UPI is created by NPCI, my lord. It is a corporation. So all these details of transaction, my lord, is with the NPCI, my lord. So unless we are able to get the details of the bank accounts in whose account the money has been.
What about investigation? You couldn't secure that person, whoever he made the call from Bihar.
Call from Bihar, my lord.
Numbers registered in Haryana.
Haryana, my lord. Yes. His location was at Haryana, my lord, at that point in time, and the number has been registered in Bihar. So, my lord, unless we get the details of the bank accounts, my lord, it is little difficult.
But they're going nowhere.
Well, this investigation seems to be a non-starter, absolutely,
Non-starter.
from day one.
You're asking it's still not developed enough in cybercrime to. You can't even. You will never be able to catch them.
If it has to be stopped, it has to be stopped within the first 8 hours.
Yeah.
Otherwise, after that.
So what to do? You'll say goodbye to the money.
No, Malaj, to this extent, Malaj, there is a circular of the Reserve Bank of India, and on the basis of which a judgment has been passed by the Honorable Guwahati High Court as well. In so far as the Malaj's account holder who has been defrauded is concerned, that money is to be refunded if it is within that stipulated period of time.
8 hours.
Malaj. 3 days. They say the circular says 3 days, Malaj. Within 3 days, if it is to be done, it has to be refunded.
Are you aware of circular, Mr. Mattan?
That we've already explained. The circular is the RBI circular is that if pending inquiry, the shadow credit.
Shadow account is different.
Yes, the inquiry was done. We found that was done from the central office. We found that the transaction was in fact done by the device which the petitioner.
Fine, it's a bona fide transaction.
Exactly.
But it's only on
if it was
inducement.
remotely done by some other device, then in that case
you're liable.
Then the refund will happen because the device, there were 4 entry made. These were OTPs were entered from that device of the petitioner. That was what was found.
No, that is the only difficulty.
That my lords, in the given facts and circumstances, I was defrauded into, my lords, sharing my OTP.
Yes.
That seems to be the admitted position.
It's a result of a fraud, but
the only thing that we can do is that
OTP
when we find that it was done by the petitioner through that device, Now we have removed the shadow entry and taken back the amount. That is the RBI circular saying that we have to do a shadow credit in the account. Pending inquiry, it's mentioned in the statement itself. That's already been explained.
But that shadow entry, well, now they're calling it a shadow entry because it actually shows that that amount was reverse credited into my account.
Not expert in banking, but this what is the exact what they call it, a procedure that they adopt now, because these nowadays is happening, and just earlier on today also another case. The thing is that now what is the exact SOP the banks have in these kind of cases? Suppose O2P comes from a registered device, or different from unregistered device or unknown device, and then from investigation authorities. So how to secure? That time to triangulate the call from where the call was made, who's the owner of the SIM card, registered with whom. Now what are the steps that there has to be some SOP?
Well, what happens usually is that, which is why the 3-day period is there, Malaj. Because if the transaction is made from account A to account B, and there's a complaint from account A saying that it was a wrong transaction, fraudulent transaction, then the entry in account B is frozen. But usually what happens is from entry account from B, it goes to CDE, because these people are smart enough to transfer the money again. So usually all those accounts are frozen, so that the money can be recovered pending investigation. In this case, I don't know, the bank would have to clarify whether they have undertaken any exercise to
freeze the account,
freeze those accounts where the money has been transferred.
Even the first instance where the money is transferred to, whether the account's been traced, who does it belong to, whether the account is frozen or not.
Bank is not able to say, my lord, in whose account money has gone.
No, that's the first thing.
It's
now,
already
other
reflected.
cases that
Lordship,
come
can you come to affidavit in opposition?
From the other parts, the police are very,
they're
very alert. Just listen, Mr. Marwan.
Yes, sir.
In other cases come for this court, what have you seen?
Yes, sir.
The thing is that once a complaint is made fraudulent and fraudulent amount has been taken out,
yes, sir,
and deposited some account, that account where the money goes is frozen straight away.
That we will not have the access to that account if it's not in our bank.
No, I mean you have to take steps.
Exactly.
Then
at least the account number.
Once the complaints come to you, at least you have to take steps before. Is it the police or whatever the authority that at once freeze the accounts?
Exactly.
Partial freeze it or freeze it.
No, it's frozen, my lords. There have been instances where we've dealt with, irrespective of the fact that it is from another bank.
Yes,
that account is immediately frozen.
Also. With this order, I mean, the amount of that came to the account, that poor person unknowingly 600 rupees, complaint was made.
Yes.
Because multiple accounts were there. Multiple accounts were there. The 84 bank accounts were frozen in the earlier case today itself. 84 bank accounts by one order.
And that happens in real time. It's done in real time.
That means when the complaint is made to you, you're slack.
The complaint is made to us and immediately
was it made
it's reflected in
of the transaction or immediately the same day?
Lordship, can you have a look at the affidavit in opposition, Lordship? The statement.
Opposition now. We want to go forward from here.
I understand, Lordship. Yes. But the statement here, there are 4 transactions made. The first transaction was 10,000. The second was 15. The third one was 45,000. The last one was 29,000. These transactions, I can see the details are here mentioned in the statement. These are the only details that we have. We don't have more than this.
No, to where the money went.
After it was complained,
it shows only the UPI ID.
UPI ID
and the
access.
It
might be an access.
No, not shows. Vijay Barik.
The name of the person is also there.
What essentially was required to be done, because it was filed on the very same day. The transaction is of 8/8. The FIR is of 8/8. The bank is intimated on 8/8. The bank must show this court that they were also, they've acted on the complaint.
Yes, we acted. It's reflected in the statement. We had done the shadow entry
to get the account to where the money went. Even this UPI account, it goes to some bank account. Doesn't mean UPI is in the air.
It goes to the bank account, my lord. That bank account details, my lord, they are not able to give us. So that we can
whatever we have, that is an incorrect statement.
Down,
whatever we have given
down today. Ms. Ensenkwan learned GA for respondents 1 to 3 has apprised the court that in spite of best efforts, it appears that the investigation is not getting anywhere. Stop, Mr. Mr. K. Police Counsel for the petitioner has also submitted that there has to be a clear picture as to what were the steps taken by the bank in this case as to whether the amount stated to be defrauded, whether the account on which the defrauded amount is deposited has been frozen, or other steps been taken by the law enforcement authorities in this regard. You file a supplemental affidavit then.
Yes, sir.
Next one, Mr. S. Marpan, Leonard, counsel for the bank, is expected to seek further details of what transpired on 8/8/2004.
Ballots.
The date FIR was lodged and the bank informed about the fraudulent withdrawal and transfer of the account of the petitioner. Just after 2 weeks, you find out. Otherwise, then we have to.
One ancillary issue. What has happened is they have blocked my account, including my FDs and things like that, Malaj, which are there with the bank.
Why? You blocked her account.
That I have to.
They have frozen my account on the contrary, Malaj, and I am writing to them saying that please unfreeze it.
It's also the courts also informed that the bank has frozen the accounts of the petitioner.
And my lords, they are telling me when I'm requesting, they are telling me that the matter is pending before this honorable court, hence they are unable. Next page, if my lords kindly have a look. There's the reply.
If the court directs you, we will.
I think we'll have to call a branch manager here.
No, because the police are still investigating, so you have not given any.
Investigating for my account, my lords, money stolen from me, my account is frozen.
And you freeze her account.
Yes, that is a normal procedure. Your Lordship, that's a normal procedure.
If the state clients that Lordship, the conduct of the bank will result in them, refunding amount of interest.
Lordship, can he have understand, Lordship? The matter is still under investigation. If the police had directed us that we can unfreeze it, we will do it. There's no direction from anyone.
Ask them for freezing the account.
The FD,
that is a normal procedure.
FD receipts are not in dispute.
When there is a dispute, we have to.
It's also informed the court that the respondent bank has.
There should be a direction, Lordship.
Has frozen the accounts of the petitioner also. Mr. Esmopran to come up with instruction the next day.
If the state directs, we will do it.
Absurd, really. We've seen other cases now. Instantly, all from where the money goes is frozen, and those people are brought to book. Whoever owns that account. That's why we have petitions here coming from all over the place.
If I may, this is of course out of this matter. There was a certain matter from Shillong, Malaj, again similar instance where there was this digital arrest and things like that of somebody who's known, and Malaj, 49 lakhs was taken away from his account. When a complaint was made, within 3 hours, Malaj, the Meghalaya police froze all the accounts. The bank cooperated. All the accounts where the money was transferred was frozen. From 49 lakhs, only I think about 2 lakhs, Malaj, they were able to take away. 47 lakhs was frozen. And that happened within real time, within 2 hours, that entire exercise was done. So here they will have to show that the bank was actually cooperative in this.
Affidavit, what did they did afterwards? Would you inform this?
Item 6.
Please, Lordship. Lordship, I pray for some time, Lordship, to file affidavit.
Yes, 157. Why no affidavit?
Respondent number 6, Lordship.
That's filed.
Not here. I still need to get the instructions.
Who's appearing for number?
I'm for 6, sir.
Lordship, I'm for 1, 2, 5, and 7.
Yes. Well, then, further 2 weeks' time granted to respondents 1, 5, and 7 represented by so-and-so, and number 6 by Mr. Marpan.
Your Lordship, may the interim order continue.
Continue next date, yes.
7.
Please, Lordship. Lordship, I'm praying for 1
will
week.
file rejoinder now.
1 week, Lordship. I'm just awaiting signatures, Lordship. I'm praying for a week's time. In the meantime, the matter may be placed for hearing.
Yes, list the matter for hearing after 2 weeks. Meantime, petitioner may file rejoinder. Yes.
Obliged.
8.
This case has become infructuous.
Your
Your Lordship, the state is yet to file their.
Yes, because the division bench has passed the order, set aside the judgment passed by this court, and given a direction to the department.
Your Lordship.
This is in which.
In fact, a general he filed an appeal against the judgment and order by this court. Now, such a direction given to the district education officer once again.
Consider the same.
To consider the proposal sent by.
But does the order passed by this court only?
Yes, that was set aside.
Yes, where's your senior?
Your Lordship, he is not available. Your Lordship, can I just.
We'll dispose it off then.
Yes, this nothing survives.
No, Your Lordship,
Yes,
if we can file.
Yes.
We can file a reply in a bit if you give us just one more.
Don't file reply, just take instructions. When the matter is called out, Mr. M.F. Kurushi, Learned Counsel for the respondent number 4, has submitted that the matter is rendered infructuous in view of judgment order dated 13/5/2025, passed in Miss Case bracket writ appeal number 79 of 2024 in writ appeal number 72/2024. Stop. Next, MS LDN, thank you. Counsel Petition, please will have to obtain instructions just after 1 week. You give a copy of the order.
Okay, this becomes infructuous.
Yes.
9.
Much obliged.
Not finally joined us. How many times you prayed?
This will be the third time, Your Lordship.
Third, final time. Yes. Last and final opportunity granted to Mr. S. Kiriam to file rejoinder just after 2 weeks.
10.
Wait, please, Your Lordship.
I am copy.
Yes, withdraw this matter.
Lordship, the complaint which is pending before the Lokayukta has been filed by some persons with regard to certain schemes with effect from 2023 onwards, when I had already assumed the post of headman. This writ petition, Lordship, is essentially praying for disposal of 2 complaints which were filed before the Deputy Commissioner way before in connection with schemes of a previous headman, nothing to do with the matter pending before the Lokayukta, Lordship.
But there's very damning things written against you.
Lordship, I have seen the inquiry report. They said that I have forged the document or something like that. So that I have, and I will participate.
Forgery.
No, that I will participate in the proceedings.
Public funds. Now, whose cause is posing with this special petition?
No. Here I am just the headman. I had lodged 2 previous complaints, which were never addressed.
You fit to be the headman if it's allegation against you of forgery and misappropriation.
Lordship, because what has happened in this complaint, I had alleged that it was the previous headman who has
done that.
Now some people have come and said that even after the new headman, even the new schemes which have come when I have been appointed, those have also gone misappropriated.
Has affidavit been filed here?
No, Your Lordship.
You file affidavit, then we dispose of.
Lordship.
Yes, Mr. SDS submits that the proceeding before the Mega Lokayukta is on a different set of complaints for different years. He prays that the matter be taken forward. Next, on this submission, Mr. Indishwal and the AG, please wait out to file an affidavit. Just after 3 weeks.
Much obliged.
11.
Yes.
Wait, please, Your Lordship. In this matter, I have filed a Impleadment application, Miss Case number 79, my Lord.
Miss Case 17?
79, sorry, my Lord, 79.
Fine. Impleading whom?
Impleading Shri Sar Borlang Saukume.
Any objection? Here's an application for impleading we have given the name. Impleading of one Shri
Shri Sarborla.
Saukumi
Yes, my lord.
as respondent number 5.
Yes, my lord.
On the ground that he was a president of school management committee of Nongse LP school for a term 2016-19. Stop. I got the same that objected to by learned counsel. You are being whom, Emerson?
Respondent number 3 and 4, Your Lordship.
Number 3 and 4. Accordingly, so and so. Address been given?
Yes, my lord.
Yes, it shall stand impleaded in the main writ petition. Registry to make the necessary addition to the cost title. Stop. Miss case allowed to dispose of. Next, in the main case, leave the order passed in Miss case 7 times so petitioner to take steps for service of notice on the newly impleaded respondent number 5 within 3 days.
Highly obliged, my lord.
This after 2 weeks for service report. Yes. How did it improve your case? Anyway.
Item number 12.
So, Lordship, I've received the affidavit, Your Lordship. So I'm bringing time to file my rejoinder, Your Lordship.
Mr. Parsante, please for allowed. How much time?
2 weeks time, Your Lordship.
2 weeks time to file the rejoinder. Please allowed. Yes, after 2 weeks.
13.
I'm praying for some more time. It's a fresh matter.
Where's the petitioner? Yes, sir. Dr. Mozika, please sponsor allowed for 3 weeks time to file affidavit. Yes, thereafter and so on. Yes.
14.
Mr. Lordship.
Yes,
respondent has filed the affidavit. The JHTC have not filed yet to file the
Lordship. The main contention of the petition is that we have not complied with the court's order, my lord, and that we have not filed application for recalling of the order, my lord.
Before the CM?
Before the CM, my lord. But they have come before this honorable court, my lord, with unclean hands, knowing very well that we did not file application, my lord.
You see, the impugned order, Your Lordship, this, but that application has to be restored. Application has not been restored, and then at that time the application was filed in the November, and this
that is not a contention,
recalling petition. You see my paragraph.
Their contention.
Then Lordship, yes.
What do you have to say?
See what I'm trying to before this comment. I have in my pleading. I'm not going to outside my pleading. It is there in my pleading. I said there was a direction from this court to file a separate application for recalling or a review petition, and also for continuation of delay. Now,
for continuation of delay.
Yes. Now, what they have done is earlier, what I've been instructed and from the record, they have filed only one application for continuation. There is no recalling application. And secondly, in the impugned order, they said now continuation they have delay. Even there is a defective. Even in the continuation also, actually, as per the calculation, there is more than 4,000 days, but they have stated only 3,000 days. And secondly, if we go by the application. In that para 2, they have misled the court that side. They are saying that there was a review petition before this honorable court. There is no review petition has been filed before this honorable court. It is there on record. I am not saying from the outside the record. It is their case. It is their pleading. And thirdly, my lord, what they have stated that in the impugned order dated 10/12/2024 is very correctly stated that continuation. They have condoned the delay and they want to fix the date for hearing on merit. Hearing on merit, Lordship. Hearing on merit. How can there will be a hearing on merit without restoring the petition that case number A
Annexure 1
appeal number 5 AC of 2017 that has to be restored first. Then only the merit. Without restoring the petition, they wanted to hear the matter on merit, and moreover, this is the order has been first affiliate in the capacity of appellate authority. This is not a case where there was a regular court and the case was dismissed on default. This is the final hearing, final affiliate court. They're supposed to, in the final, can they file a record? Now our contention is.
What did they say in the affidavit?
They say that they have filed an application for restoration. That was they have enclosed. Even in that application also, both in the recalling petition and also in the petition for condonation, they have make a very make a wrong statement, Your Lordship. I will take one of that. Kindly take the page 51 of the.
Then you file a rejoinder. Then.
Yeah, Lordship, I'll file it.
When are you going to file affidavit, Mr. Day?
I am still awaiting instruction. I'm praying for 3 weeks time.
There's ex parte against them.
Lordship?
No,
my lord.
The order is very clear. They are ex parte. If you go by the order dated 10, this one.
Hearing, my lord.
See, page 33.
Direction was to file 2 separate applications. That was so done. Now delay was condoned. Parties were put.
Then what remains? Let them you contest the matter.
No, Lordship.
His contention before this honourable court is that, my lord, we have not complied with the honourable court's order, my lord, 15/11/2023, that we have not filed a separate application for recalling of the order, my lord.
That is one.
So that is his contention, my lord. He knew very well, my lord, that application we have filed it, my lord, and we have brought it on record, my lord.
That is one of the aspects, Lordship.
After it's since been filed by respondent number 4 and 5, to which Mr. P.T. Sangma account praised out for the joinder. It appears that the records of so-and-so are necessary since no affidavit is being filed by the respondent number 1, 2 and 3. Yes, sir, the records reproduce next date. You see if the records, if they file it, it's over. We don't need arguments.
Yes, if they file in there, we may withdraw, but I will give an opportunity to establish my case. Because that is their allegation.
Will impose cost.
No, Lordship. Because
Item 15.
Yes. Much less, Lordship.
My lord, item number 15.
Yes.
We are entering appearance for number 2 and 3.
2 and 3 is?
The
Golf Union.
Indian Golf Union and the Director General. Okay, very good.
I have filed the affidavit on maintainability purely, and yesterday we have received a reply from my petitioner. They reply. However, my lord, I received the brief yesterday only, so I pray for my lord.
Right.
We'll fix the matter next week, my lord, for hearing of the
there is one difficulty. That, my lords, what happens is we've received some communication from the government of Meghalaya. This is with regard to grants, my lords, to be given to the golfers, last date of which is on the 26th. Now, because of this scenario, my lords, we are not able to recommend anybody's name. And ultimately,
recommend now Shillong Golf Association is recognized, correct?
They can't recommend.
They're recognized by the Indian Golf Union, correct?
Yes, my lords, but that's
they're not. Mr. Paul, as it stands today, as you're standing there, who's recognized association from here?
My lords, it's not a question of recognized association.
It's an affiliated association.
My lords, as on today, it is Shillong Golf Association from the IGU. But what happened? They are not recognized by the Indian Olympic Association, my lords.
IGU?
Yeah, no, my lords. The Meghalaya Golfers Association.
By the Meghalaya Olympic Association or by the
Meghalaya and the Indian Golf Association, they don't recognize them. We are the recognized body. That's why this letter has been issued to us. It's addressed to us. I've just placed it. Courtmaster, if you could kindly just place it before the court.
It's blank. It's to whom is letter?
My lords, if my lords kindly have next page, my lords, page 2, serial number 21. Golf Promoter Society. That is the petitioner before your lordships. Now, what we are required under this one.
Question.
I'm sorry.
Which is outside the purview of this discussion. How many golfers are registered in Shillong Golf Club or Shillong Club?
Shillong Golfers Association?
No. How many golfers are there who play regularly? I want the list, or those who pay green fees to play for a short while.
Well, we can file that. I'll have to file it. I'll have to seek instructions. I don't have it.
We'll have a floor test.
We can have a floor test. That's there. The issue here is, well, I'm only praying, my lords, may kindly have it on Friday. My friend says that he has something.
We'll take up your other Miss case first.
My lords.
Yes.
So by then we'll also conclude this, my lords.
Miss case number 87, 25 in December 154 2025. Stop. First the main case, sorry. The main case first 154. Mr. H.L. Changri, so Senior Counsel with Mr. T. Dakhar has entered appearance, has appeared on behalf of the respondents number 1 and 2.
2 and 3.
2 and 3.
Submitted by Mr. Changri, so as it is submitted by Mr. Changri, so they've just been engaged in place for earlier counsel, and he prays that the matter be taken up on Friday for further orders. Stop. Prayers allowed. Main case is on Friday. Stop. Miss case number 87, different order sheet. This is an application filed by the petitioner for impleading the Shillong Golfers Association as a party respondent.
Number 4, my lords.
As participant number 4 in WC number 154 of 2025. Stop. The same not objected to by the counsel for the respondents. Like accordingly, the Shillong Golfers Association, represented by Secretary, stands impleaded as respondent number 4. Number 4. Stop. Registry to make the necessary corrections or addition in the cause title. Stop. Miss case is allowed and disposed of. In the main case, also next part in view of the order passed in this case also. Petitioner to take steps as of notice within by postal service within
by tomorrow,
within 2 days upon the duly plead respondent.
Lordship, sir, permit me allows to serve Dasti, my lords.
Yes, by postal service.
Yes.
So this on Friday. Today is Tuesday.
Today is Tuesday.
How many golfers are there? Okay.
There will be substantial number of golfers, my lords.
16.
How many associations are there?
Well, there are 7. There are 7 associations, well, 6 of them are affiliated with us.
Politics.
Unfortunate part, my lords. It's plaguing every sport.
Right now, tournament play out. Shillong Golfers Association of Shillong Promoters. Who wins will be affiliated to in the golf union. Best thing. That means the ones who win the better, they're more adept at the game.
Yes. Better golfers, my lords.
Better golfers, right?
Give you a minute.
16.
Wait, please, Your Lordship. Your Lordship, I'm praying for some time. I'm awaiting instructions. However, Your Lordship, I'd just like to point out that Annexure 7 is an incomplete document, Your Lordship.
Take care of it. Take care of it, my lords, in case there's some pages.
MSN Country Senate Council for the SLG has paid for further
2 weeks' time, Your Lordship.
Which he has also submitted that the Annexure 7. I hope it's complete in the court's copy.
My lords, we'll verify it. We'll verify it.
Annexure 7, which has been annexed preparation, is incomplete. Mr. K. Paul submits, he'll verify and file complete copy if the same is correct. And this is matter for 2 weeks. Interim orders, if any, shall continue the next date.
Yes.
Obliged, Lordship.
One thing, who's appearing election matter?
Item number 3.
How many witnesses do you have? You ready today with the witnesses? They're ready with the witnesses today?
Yes.
So we'll do one thing. Take the positions. Yes.
All right.
You want to continue with the meal list?
All right.
Okay.
You can go and have lunch in the meanwhile.
Yes.
Hearing. Hearing supplementary list. Item number 9.
No.
1 lakh each.
It will be 50,000, Your Lordship.
50,000.
Considering the fact, Your Lordship, that they were not in service, Your Lordship.
50,000.
My Lord, my prayer is 10
You don't
months.
forget your prayer.
No, at least my Lord, what my Lord proposed, 1 lakh, still is okay. My 50,000, my Lord will
How many
kindly.
are there?
27 months I
How
have.
many are there?
Three
How
of
many
them,
three
Your Lordship.
Three.
Three of them.
Give them 1 lakh each.
27 months,
It will be
Lordship.
50,000, Your Lordship.
27
Considering that
months.
they were not in service, Your Lordship.
At the fact
they did
and
not render any work, Your Lordship.
after serving 38 years, Lordship, 37 years, at the fact and because I have agitated matter,
60, Your Lordship.
I have been thrown out.
There will be 60,000 each, Your Lordship.
Well, make it one.
700? What do you think?
60,000 each.
Make it 1 lakh, Lordship. What my Lord have, that is the proposition. Proposal has come from my Lord.
Yes.
Considering the fact, Your Lordship, that they were not in service for from December, Your Lordship, 22, Your Lordship, to June 23, Your Lordship.
See, they will have informed. And
Lordship,
if you pay
in fact,
regular pay, how much will be entitled each?
My
we
Lord,
have told them, Your Lordship. We have told them. We have informed them, Your Lordship.
The pay they were drawing, last pay.
27,000 something like that is.
You just calculate. You give me a calculation on paper. We will pass orders. Matter heard reserved. We will pass orders.
All right, Your Lordship.
See, the thing is that I'm taking the consent order, Mr. Shila. I'm recording that.
Lordship, my submission, Lordship, 50, Your Lordship, or 60, Your Lordship.
Item number 10.
Your Lordship.
10.
This is the matter concerning the CDPOs. My Lord had already passed an order on 17/12/2024, Annexure 1, page 20, my lords. Operative portion is at 21.
Annexure?
Annexure 1, my lords, of the miss case.
Of the?
Miscellaneous case, my lords, that's been filed today. This is miss case number 86 of 2025.
Yeah.
My lords, can you have a look at page 21?
Yes.
Last paragraph, my lords. Considering the submissions of the Learned Counsel for the parties and on perusal of the advertisements which indicate that the last date for submission of applications is so-and-so, in the interest of justice, though the selection process can carry on, the same shall not be concluded or finalized until the matter is taken up or other orders passed on the next date. This was the order passed, my lords. Matters pending before your lordships. Now, what they have done is, my lords, they have gone on to declare the final results.
This is Annexure 2.
My lords. This is on 15th of May. Now, what essentially this will do is, my lords, it will create third-party rights.
Why is this done? In fact, this order? This order is very clear.
Yes, Your Lordship, order is clear, but why they have done, I have to seek instruction.
You get your instructions from this case number 86/2025. Stop. This is an application seeking stay of the operation of results dated 15/5/2025, declared for the post of CDPO in the Social Welfare Department, ICS Meghalaya. Stop. It's next file submitted by Mr. K. Paul that this court by order dated 17/12/2024 passed in Miss WPC number 219 of 2024 in the main writ petition being WPC number 25 of 2024 had directed that and ordered that had directed that though the selection process for the post of the CDPO could carry on, the same was not to be concluded or finalized until the matter is taken up and other orders passed thereafter. Another senior counsel has taken this court to Annexure 2 of the miss case, which contained the notification, which is the notification dated 15 May 2025, wherein the results of the interview have been declared. As this appears to be in the face of the order dated 17/12/2024, the same shall not be given effect to until further orders of this court. Stop. MS Barasaji, Leonard GA, praise so allowed 2 weeks time to obtain instructions. Just thereafter. Why was it declared? There will be liable to contempt.
Yes, Your Lordship.
I hope they were informed.
Yes, Your Lordship,
They were informed of the interim order.
That interim order to
Department was very much here before your
because petitioner himself has forwarded.
Daily list, item
Much
18.
obliged.
18.
Where is this matter situated now?
Well, it still remains in the same place. This matter, Mills, what at some point we had also earlier pointed out that the affidavits which have been filed, Mills, is not by the competent authority.
Is the contempt?
Which matter? In the contempts and the main matter, Mills.
Yes.
So what we had pointed out, Mills, that the affidavit essentially had to come from Mills, the competent authority would be the secretary from the government of India. Mills, that has not come till now. Because this essentially is
so
that
what happened? That's the recalling of the transfer policy, correct?
Mills.
After undertaking it before
this court saying that Mills.
And where the petition is situated, they are not affected.
Petitioners, Mills,
Where are they?
They are affected, Mills. If the new policy is put into place, then
no. I mean, where are they right now?
As on today, Mills, there is some interim protection, so we are protected.
Yes, Dr. Musica.
Well, the affidavit is filed on behalf of the then DGR, Malad. If that is the case, they have to amend the cost title itself.
No. I mean, we can't have that. Contempt is personal. You can only add the respondents. You can't subtract. You can't subtract them.
Well, it's page 3 of my contempt application. Your Lordships will kindly see that the secretary is very much a party.
Mr. Bhalla can note.
Mr. Page 3 of the contempt application.
The current DG?
No, he was the secretary of the Ministry of Home Affairs.
Oh no, that's Mr. Bhalla now. He's the governor of Manipur.
He's retired during the pendency.
During currency of this matter, Malaj, I think. Now, the affidavit is filed by one Dr. Akhil Chandra Karmakar.
ADG Medical.
Since it's a question of policy, Malaj, that would come straight from the top. So it essentially has to be from the government of India.
Even if when other secretary also. Or joint secretary.
Malaj.
Yes, Dr. Musica, how do you resolve this issue? But is the affidavit contain enough materials that we can go ahead?
I would humbly submit no, Malaj. You cannot pass the buck because essentially what they would essentially do, Malaj, they're saying that it's a new policy. Once an undertaking is given before this court, Malaj, it is expected of the Union of India, Malaj, that this matter should have been examined. It seems, Malaj, there's something that is probably not in the know of the Union Ministry. Otherwise, an affidavit ought to have come from them.
Is that filed by whom? By Assam Rifles only?
Assam Rifles only. ADG Medical.
It's submitted by Mr.
Malad, kindly see the affidavit of. Well, he doesn't belong to Assam Rifle cadre, Malad.
Who?
Akhil Chandra Kamkar. He is one of the respondent, Malad. Malad, here what happens, Malad, the respondents in official capacity, they change the transfer and posted, Malad. Now, in the contempt application, ADG Medical has been read as a party, Malad, as respondent number 2.
He filed affidavit.
So, but in the meantime, Binay Kumar Agarwal is not there. Akhil Chandra Kamkar is there, Malad, and he is filed an affidavit.
See, it's not that number 2 fine, but from number 1, I think
number 3 also is filed, Malad.
Who generates the policy?
Malad, policy is from Ministry, Malad, and Akhil Chandra Kamkar is representing Ministry, Malad.
He's part of Ministry by Director General,
Additional Director Medical, CF, PF, NSG, and AR. And he's overall. He doesn't belong to Assam Rifle alone, Malad.
But be that as it may, Malad, he would not be the person in charge of policy.
He is in charge of policy.
He's just acting on the policy. He would not be the policy maker.
Let's see the affidavit filed by him.
Malad, if I may pray, your Lordships take up the main writ petition, because the contempt, Malad, the respondents are coming and going. In the main writ petition, the affidavit has again come from Additional Director General Tapan Biswas has filed it.
The 329.
Yes.
Tapan Biswas.
He was then additional director general.
He's the ADG.
He's the ADG.
Yes. They will hear it some other day.
Plus, this would require some hearing. I'm only praying, my lords, let the secretary file a formal affidavit clarifying the stance. What is the position?
Writ petition is 22, my lord.
We'll take it forward. Let's see. Let's hear it. Because then if orders have to pass, instead of dabbling around with contempt and waiting for additional parties.
Which is why I submitted, let the main writ petition
The thing
be
is that, yes, I mean, because as it is, they're suffering long enough.
Lordships.
There is a stay.
Correct?
As far as petitioner, there is a stay, my lord.
There's a stay, of course, but then it has to go forward. It can't be left.
There has to be some quietus to this entire thing.
Yes, Mr. K. Paul, when the matter is taken up in the contempt, contempt numbers also have submitted that there is no affidavit as yet from the side of the Home Ministry, to which Dr. N. Mozika submits that affidavit, but respondent number 2 should suffice in as much as he is the Additional Director General
All CPFs.
of the CPFs medical. Yes. And as such, his authority to formulate policy. Be that as it may, in the considered view of this court, the main repetition it would be expedient. The main repetition is disposed of before the contempt matter is taken up finally. Yes, and the main repetition. When you want it?
After a week, let's.
Yes. Main repetition, that is 329. This matter on request of parties matter for hearing on so and so.
Maybe we pray for the 4th of June, my lord, subject to convenience of the Honorable Court.
Yeah, 4th of June.
Live stream.
21.
You file documents.
Well, these are from the lower court records only.
You have not filed it. You're supposed to file by affidavit, correct?
Basically, my lord, I am not relying on any new documents. My lord, what I am relying upon is the lower court records which have been called, my lord.
You can file it by affidavit, my lord.
If I am required to file by affidavit, I can file, my lord. Because basically,
your junior that day she took. Yes.
Basically, what I had said on the last occasion is, my lord, I'll rely on certain papers. This is the first appeal. Otherwise, paper book should have been prepared. My learned friend has not prepared the paper book. My lord,
because
just few.
See, the thing is that it is not a, not something regular. It's not a standard first appeal because you are not aggrieved. Your opponent should be aggrieved.
My lord, I should have been.
You want that money be returned back to them. That's all.
After going through the entire records, my lord, what I have understood of the matter here is, my lord, the collector, rightfully said by my learned friend, was never aware about the agreement. So in such a situation, my lord, the lower court could not have decided the reference by saying that, my lord, I am entitled to get that payment. The lower court, I mean the special court, should have answered the reference. And by not answering the reference, my lord, now even though it's his appeal, I am aggrieved. My lord, I would pray at this stage, my lord, the matter be remanded back.
Yes.
That is the only thing that can be done here, my lord. Even though it's his appeal, I have every right to point that out.
My lord, I will go through these papers, my lord, and let us have a hearing on the next date, my lord. If necessary, my lord.
Because even though it's his appeal, my lord, after if I'll point out.
Okay, we'll accept it. Mr. Kesej Gautam today has produced certain documents.
These are part of the LC records.
Yes,
I have not bought anything
extra.
extra.
To be part of the low court records to assist the court. So the same are taken on board. Same taken on board. Yes. List the matter for hearing after 1 week. Yes, you come prepared.
Yes, ma'am. Oblige.
Much obliged.
24.
Which yes.
My lord, that conducting counsel, Mr. B. Patas, is some personal difficulty.
Who's the conducting counsel?
Mr. B. Patas, my lord.
After 2 weeks, yes.
28.
Very unfortunately, my lord, here, my lord, we have communicated with them so many times, my lord.
Yes, we close it. Mr. S. Thapa submits that in spite of his repeated best efforts, he could not contact the petitioner who appears to have got interest in the matter.
I have a small prayer, my lord, as per what I have been instructed by
We'll
my
dismiss it
senior.
non-prosecution and then you can restore it.
No, no, my lord. I have a very small prayer, my lord. Here, my lord, it appears that the clients are non-responsive, my lord. So we are withdrawing ourselves from this case, my lord.
We'll dismiss it.
The matter will be dismissed.
Yes. Because he didn't get the contract, right?
He did not get the contract, my lord.
He's
Here,
L2,
my lord. We have been.
He's L2 and he is challenged.
Yeah.
Only issue is, my lord, here I'm not going on merits. What I'm only saying is, my lord, we had tried our level best to
protecting your own interests.
My lord, we have no instruction whatsoever to withdraw.
Say protecting your own interests. That's
My
say
lord.
that. So take down. Mrs. Thapa today also has submitted that in spite of best efforts, they could not obtain any instructions or contact the client in any manner. Stop. He prays that he may be able to withdraw as counsel for the petitioner from the said case. Stop. Like Dr. M. Muzika submits that perhaps the reason for the writ petitioner not being interested in the proceedings is due to the fact that he was not the lowest
L2.
lowest
He
highest.
was L2.
He was L2 in the bids. Stop. Like
L3.
Upon hearing the constitutions, this is a matter after 1 week.
My lord,
In
if I
case
may,
of
my
last
lord, I pray, my lord, if some notice is issued to them.
1 week on which they further orders will follow. You take whatever steps you have to do. We won't issue notice.
What I pray, the matter can be dismissed. If they are interested, then come back, man. For registration.
Will be dismissed next week on non-prosecution.
29.
My lord, here what happened, my lord?
Yes, Mr. Chanda.
The implementation, I have filed a miscase, my lord. What happened during pendency of the writ petition, they have issued a reversion order. Reversion order when the matter is pending. And
What is this?
I have filed a miscase, your lordship, annexure the reversion order.
Annexure what?
Annexure 1 is the reversion order, my lord.
Page 11 of the
Case
miscase.
relaxation to the for 18 years we are working, my lord. We have been employed for 18 years. We have been
Where is it, Mr.
obtained diploma at the instance of Assam.
Miss case 85, Lordship, page 11, annexure 1.
I humbly pray, my lord, this order may be stayed till disposal of the order. So far as petitioner is concerned. Petitioner is number 1.
Where are you now?
Now, my lord, this order has been passed and now I have.
You are, where is your name here? You are number
1.
Number 8. Ran Vijay Singh.
Right.
You are
Yes.
what is this parent unit? You are now in
ARTs.
where is this in Shillong?
No, matter. This is Assam Rifle Training Center. This is in Sukhovi, Nagaland.
Now his parent unit is 26. Yeah, where is it
26 AR
located?
Well, there is no ground for staying, my lord. Well,
Till the matter is, my lord, like hard, my lord. Your lordship will fix a short date for hearing, and your lordship, till such time, I may be protected.
Well, here what happened, my lord?
Yeah.
Well, the petitioner is general duty personnel, my lord.
Yeah.
And during service, he opted for some engineering diploma, my lord.
Yes, I remember.
So he went on engineering diploma, my lord. Now, after coming from there, he is claiming that he should be remustered as Naib Subedar. But next post for him will be Havaldar, my lord. Then come the question of Naib Subedar.
No, my lord, they have deputed us for 2 years diploma.
I'll just
2 years diploma, and thereafter,
I'll just come.
Okay, take down this miscase no 85 2025. Stop this application. This misapplication has been filed, praying for stay of an impugned reversion order, the impugned reversion order dated 28/4/2025, whereby the petitioner was posted at ARTC capital and S capital, Dimapur, bracket engineering branch, has been sought to be reverted back to parent unit, that is 26 Assam Rifles. Stop.
8 years, sir. Since 17.
26 Assam Rifles. What are they doing? It's submitted by Mr. M. Chanda that this reversion order has been passed while the writ petition, that is WPC number 464 of 2024, wherein the writ petitioner has filed for consideration of his 3 masteration as Naib Subedar is pending. Stop. He is further submitted that the is pending. Stop. He therefore prays that the main matter be decided expeditiously, and meanwhile the order dated the 28/4 annexure 1 to the instant application be not given effect to. Stop. Now your submissions.
My submission is that, my lord, he has no right to remain in the same post, my lord.
Dr. N. Mozika, learned DHI, has in reply has submitted that the petitioner has no vested right to continue the same post.
Where is continue for last 8 years.
Where he has continued for the last 8 years.
18 years,
and his
18 years I am serving.
In this place, 18 years.
18 years I am serving.
18 is total service. Total service 18.
Okay, yes. 8 years in the certain post, and submits that the reversion order is part of the normal administrative process. Next, having heard in the council of parties, though it is correct that the writ petitioner has served for 8 years in the said post, considering the fact that the matter is in the final stage of hearing, the revision order shall be given effect to till the matter is disposed of finally.
I'm not even.
To the next date.
I don't have instruction whether because the 28th April, today we are on 20th of May. That's one aspect.
If the revision order if not already affected, shall be stayed until the next date, as far as it is concerned.
Right. But they'll not seek adjournment.
Yes.
Matter can be heard expeditiously.
Yes, this is a matter for expeditious hearing on so and so.
Okay.
Yeah.